When you have to resort to celebrating common sense coming out of the court system,
you know you are in dire straits.
Viva Frei, Montreal litigator turned YouTuber, and this is Winnie the Westie. That was Winnie the Westie, and we're going to take a break from the Ghislaine Maxwell, Alec Baldwin, Kim Potter, Jussie Smollett stories, and we're going to get back to Canadian news, because every now and again, Canada makes international headlines, and when it does,
typically it's not for good reasons.
Montreal once made the headlines on CNN when the city decided it needed to divert raw sewage directly into the St. Lawrence River in order to perform an update on its sewage system. Montreal dumps 2 billion gallons of raw sewage into St. Lawrence River. I was actually working in Old Montreal at the time this occurred, and Old Montreal is right on the St. Lawrence River, and I went down to see what was going on during my lunch break because rumor had it the city was being warned to stop flushing condoms down the toilet because the sewage was going to be diverted into the river. I went down there. There was nothing but condoms floating around on the water. So it's day 2 of the Montreal sewage dump. Condom. There must be 15 condoms there. Speaking of raw sewage, another time Canada made the headlines, this time on Fox News. It was back when Justin Trudeau had that whole makeup incident. Fox News, Justin Trudeau blames privileged upbringing for wearing blackface after third racist incident emerges. And more recently, this time in the context of COVID, Canada again made international headlines, this time because of its propensity for arresting pastors. Canada has literally arrested no less than 3 pastors for violating public health orders: Tobias Thiessen, James Coates, and Artur Pawlowski. The story of Pastor James Coates is somewhat less well known than Artur Pawlowski because nothing really went viral in that situation, but if you can believe this, Pastor James Coates was jailed for 35 days and spent something like 2 weeks in solitary confinement because of COVID protocol, but the video heard round the world was Artur Pawlowski telling the Alberta Health Services to get out of his church.
Get out of this property. Immediately get out. Okay. Get out of this property immediately. Out. I don't want to hear anything. Out of this property immediately. I don't want to hear a word. Out. Out. Out of this property immediately until you come back with a warrant.
Alberta Health Services, with the support of the police, showed up at Pastor Artur Pawlowski's church to tell him that he was in violation of the public health orders, that he was having unlawful gatherings. He told them to get out, and that video went viral around the world. The only problem is that the Alberta Health Services and the police did in fact get out, only to come back at a later date to serve Artur Pawlowski with a court order enjoining him to not hold unlawful public gatherings in his church. Artur Pawlowski violated that court order. He was found to be in contempt of court, and he was arrested not once but twice, but the video of one of his arrests also went pretty much viral.
After receiving new enforcement powers for public gatherings Thursday, Calgary police have arrested Artur and David Pawlowski, 2 church leaders notorious for organizing against public health measures.
No it to Nazi style! No it to taser me, kill me!
CPS say they headed to a church before service Saturday morning and warned the organizers ahead of time to follow the rules, which were then still disregarded. The 2 have been charged with organizing an illegal in-person gathering, including encouraging others to join in. Police ask anyone organizing or participating in any outdoor events to make sure they are familiar with health guidelines.
So Artur Pawlowski, one of 3 pastors in Canada to be arrested for violating public health orders, was arrested not once but twice. And it wasn't just his arrest. He was found to be in contempt of court, and the court order sanctioning him for his contempt also went viral for all of the wrong reasons. I've done a bunch of videos on that, so I'm not going to read that provision of the court order right now, besides which it's in the judgment at issue in this vlog. But Artur Pawlowski and his brother David Pawlowski petitioned the Alberta Court of Appeal to stay certain provisions of that contempt order against him, and lo and behold, hallelujah, he actually succeeded in having certain portions of that contempt order stayed. Thanksgiving may have passed in Canada, but I think we can still nonetheless show a little bit of thanks for a little bit of common sense coming out of the court system. Here is the judgment. Between Alberta Health Services respondent and Artur Pawlowski, David Pawlowski, and John Doe's applicants. Christopher Scott, Whistlestop 2012 Limited, Glenn Carrott, and Jane Does, not parties to the application or appeal. Just to explain what's happening here, because it might be a little confusing, the Pawlowski brothers were found to be in contempt of court for violating a court order to a lawsuit to which they were not a party. Now, more often than not, in order to be in contempt of court by violating a court order, you need to be a party to the suit, but not always. If you were made aware of an order of the court and you violated that court order, it doesn't matter if you were a party to that suit. If you knowingly violate an order order of the court, despite not being a party to that lawsuit, you can still nonetheless be held in contempt of court. This was the nuance of the Pawlowskis' contempt charges, in that they were not parties to the initial lawsuit, but they were made aware of the court order enjoining public gatherings in violation of public health orders. They were made aware of that court order by Alberta Health Services and the police, such that when they violated that court order, they were in contempt of court for violating a court order, even if they were not a party to that suit. Introduction. In May and April of 2021, Alberta Health Services, AHS, obtained 2 orders from the Court of Queen's Bench. These orders were both designed to assist with enforcing COVID-19 community compliance with AHS health orders made in response to the COVID-19 pandemic. The applicants, David and Artur Pawlowski, are brothers. Artur was found in breach of both orders. David was found in breach of one order, and both were found guilty of civil contempt. And wait until you hear the sanctions that were rendered against them by the court. Following a subsequent hearing, the following sanctions were imposed on Artur. 1. A sentence of 3 days in prison deemed fully satisfied and served. 2. A fine of $23,000. 3. 18 months probation, during which he will be required to keep the peace and be of good behavior, obey all AHS health orders relating to COVID-19, and provide 120 hours of community service work at a rate not less than 10 hours per month, working at a homeless shelter, a food bank, for Meals on Wheels, or any other facility and charity, but excluding the Street Church Ministry. The Street Church Ministry is Pawlowski's own church. But wait, this is the part of the order that shocked everyone's conscience. A requirement that during the period of his probation, when publicly speaking against AHS health orders and health recommendations, that he indicate the following, quote, qualified speech provisions, end quote. I am also aware that the views I am expressing to you on this occasion may not be views held by the majority of medical experts in Alberta. While I may disagree with them, I am obliged to inform you that the majority of medical experts favor social distancing, mask wearing, and avoiding large crowds to reduce the spread of COVID-19. Most medical experts also support participation in a vaccination program unless for a valid religious or medical reason you cannot be vaccinated. Vaccinations have been shown statistically to save lives and to reduce the severity of COVID-19 symptoms. The court quite literally drafted and crafted speech that Artur Pawlowski was compelled to say when speaking against AHS health orders. The court literally told him what to say when he was exercising his free speech. Pawlowski appealed the sanctions against him, but not all of them, because some of them had already been satisfied by the time of the appeal. The applicants have appealed the sanction order and seek a stay of enforcement of that order pending its appeal. Since the application was filed, the applicants have paid the costs and fines awarded against them in full. As a result, it is not necessary to address those aspects of the sanction order on this application. Alright, I'm losing light quickly because we had a problem with our furnace and I was in the house talking to the gas met guy who was there to repair the problem. It literally sounded like whales were making love in our furnace, and hopefully the problem has been resolved. But getting back to the court order itself. The court order goes over the rules that are applicable to a stay of the proceedings, and they are basically the same rules that are applicable to the issuance of an injunction, and they are as follows. Test for a stay pending appeal. Rule 14.48 of the Alberta Rules of Court provides that a stay pending appeal can be granted by a single appellate judge. The test is set out in RJR McDonald Inc. versus Canada Attorney General. The applicant must establish that 1. There is a serious question to be considered on appeal. 2. The applicant will suffer irreparable harm if the stay is not granted. And 3. The balance of convenience favors granting the stay. The court goes on to specify that the criteria of a serious question is a relatively low threshold. There just has to be a meaningful question at law in order to satisfy that condition. Then they get into the irreparable harm condition. Irreparable harm, quote, is harm which either cannot be quantified in monetary terms or which cannot be cured, usually because one party cannot collect damages from the other, end quote. AHS concedes that the applicants may suffer irreparable harm if a stay of the qualified speech provisions is not granted pending the appeal. AHS denies that the evidence put forward by the applicants established that they would suffer irreparable harm if travel restrictions and remaining probation terms are not stayed. Without deciding the issue, I am satisfied that the applicants have demonstrated that the qualified speech provisions and the travel restrictions arguably affect their mobility rights and rights to free expression guaranteed by the Charter of Rights and Freedoms. If these are set aside on appeal, the impairments cannot be remedied and thus constitute irreparable harm. Finally, a little common sense and just an iota of respect of our constitutional freedoms coming from the court. The judge then goes on to address the balance of convenience argument and ultimately finds in favor of the Pawlowskis, but the Alberta Health Services raises an interesting argument that is worth noting. The balance of convenience stage requires the court to consider which of the parties would suffer greater harm if the stay were or were not granted. Public interest considerations are applied at this stage. There is a public interest in upholding the rule of law and the enforcement of court orders that are prima facie valid pending their review. To the extent that the AHS submits that the applicants do not come to court with clean hands seeking relief as they have breached alleged health orders granted by the chief medical officer. Since the sanction order was granted, the appropriate authorities are at liberty to seek to enforce such orders or the provisions in the sanction orders as they see fit. In the circumstances, I am of the view that an appropriate balance of the competing interests of these applications would be to stay the qualified speech and travel restriction provisions of the order and direct the appeal proceed on an expedited basis. The remaining provisions of the sanction order shall continue to apply pending its appeal. The judge here is saying that there are basically diverging interests. There are the charter right interests of the Pawlowskis, and there is upholding the rule of law and respecting prima facie valid court orders. Ultimately, the judge finds in favor of the Pawlowskis, but Alberta Health Services, the AHS, say that the Pawlowskis have not come to court with clean hands, and therefore their request to stay the appeal should not be granted. AHS is arguing that the Pawlowskis have violated other provisions of that court order since the issuance of the court order, therefore they come to court with dirty hands, they come to court having broken the rules, and therefore the stay should not be granted, to which the judge basically says, you are always at liberty to petition the court yet again for more contempt proceedings, and my fear is that this is exactly what the AHS is going to do. Destroy the Pawlowskis through the process. When the video went viral of Artur Pawlowski telling the AHS and the police to get out, get out, get out, I said, yeah, they're going to get out, and they're going to come back with a court order, which is exactly what they did. And here you basically have the court telling the AHS, if you think they're in violation of the court order, petition the court again for more contempt proceedings. And because the government is paying for all of this with our tax dollars, it's like playing poker with other people's money. I have no doubt that they're going to go ahead and do that. We will see what happens. I will do a follow-up as it happens, but at the very least for the time being, the provisions, the offensive provisions of that court order have been stayed pending an appeal, and hopefully they get overturned outright on full appeal. To be seen, to be determined, but if you like my videos, you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below because it feeds the algorithm.
You can't trust the system!
If you want to support the channel, all of these support links are in the pinned comment. Robert Barnes and I do live streams every Sunday. We do streams with a guest every Wednesday called The Sidebar. If you want to find us and support us on Locals, where supporters get lots of exclusive content, you can find us at
VivaBarnesLaw.locals.com.
All of my content is also on Rumble, so you can catch it there, but more important than anything, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. And I am closing the lighting, the warm, glowing glow of my computer. Peace.
No.